You knew it was coming. The state of Texas has just sued the Biden administration over the recent guidance that requires hospitals nationwide to provide emergency abortions regardless of state laws. The lawsuit asks a federal judge to block that requirement. Texas's attorney general put out a statement about his lawsuit saying the Biden administration seeks to transform every emergency room in the country into a walk-in abortion clinic. Now, I told you all about this specific guidance issued by the Department of Health and Human Services in this video just 2 days ago. That guidance relies on a 1986 law called the Emergency Medical Treatment and Active Labor Act. That law requires all hospitals receiving Medicare funding, which is like all of them, to provide patients with appropriate medical screening, examination, stabilization treatment, and transfer if necessary. The physician or qualified medical professional has a legal duty under this law to provide stabilizing medical treatment to a patient who presents with an emergency. Now, Health and Human Services says emergencies can include, but are not limited to, ectopic pregnancy, complications from pregnancy loss, and emergent hypertensive disorders like preeclampsia. And yes, by federal law, according to HHS, that stabilizing medical treatment can be an abortion. And no, it doesn't matter what the state law says. In response to that video, lots of you commented that there's no state abortion ban that doesn't allow for an abortion if a woman's life is at risk. But what you're missing here is under the interpretation of this 1986 law by the federal government, it also allows for an emergency abortion if the woman's health is at risk. Life and health are two very different things. And the question of what constitutes an emergency has left a lot of healthcare providers across the country with questions about what's legal and what's not. Regardless of life or health risks, and despite this law that's been on the books for more than 35 years, this new Texas lawsuit challenges the actions of the Biden administration, saying that law does not explicitly authorize abortions. That's actually an HHS interpretation. It challenges the HHS guidelines and interpretations of the law on the grounds that it uses Medicare funds, saying that's a violation of the Hyde Amendment, which bars federal spending to facilitate abortions. Now, this lawsuit will make its way through the federal court system.